So we've jumped forward a significant amount of time. We're now to 1947. The court is very different. The landscape of the country is very different. But this issue of the 14th Amendment and its applicability to states is still an issue. So let me give you the facts of Adamson v. California. So Adamson was convicted of murder in a California state court and sentenced to death. At the trial, in accordance with state law, the court and the prosecutor commented on Adamson's failure to explain or deny any evidence against himself. And the law at that time in the state of California, this was absolutely permissible. Although, it should be clear, if the Fifth Amendment applied to the states, this would have been prohibited because no person shall be compelled to testify as a witness against themselves. So in essence, the state of California had no similar Fifth Amendment type protection, and therefore Adamson was called out, and it was made clear to the jury in the case that this individual not testifying against him or testifying in defense of himself should be thought of in a fashion as evidence of his guilt. So this Fifth Amendment protection simply was not in existence in California. And so Adamson was, at least in part, likely his conviction was contributed to by this fact. So he brings issue with the Supreme Court, the United States Supreme Court, with the argument that, with basically asking the question that, making the argument that it does, that the protections of the Fifth Amendment apply to citizens in state courts because of the 14th Amendment protection of equal, or the 14th Amendment clause of equal protection. So in essence, the argument that Adamson's making is that the Fifth Amendment's prohibition upon self-incrimination should be made applicable to state courts because the 14th Amendment's equal protection clause exists. The defendant, in this case Adamson, argued that the Fifth Amendment protections provide for, quote unquote, fundamental rights which no state can deny due to the 14th Amendment. This idea of fundamental rights is important, and it's one that we will absolutely revisit. In plain terminology, he argued that fundamental rights have to be incorporated through the 14th Amendment to be applicable upon the states. That anything that is fundamental in nature has to be made as a restriction upon the states. The court in 1947 does not buy this argument. The majority of the court held, and this is quoting, "It is settled law that the Fifth Amendment protecting a person from being compelled to be a witness against himself is not made effective by the 14th Amendment as a protection against state action on the ground that freedom from testimonial compulsion is a right of national citizenship, or because it is a personal right secured by the federal Constitution as one of the rights of man that are listed in the Bill of Rights. Therefore, no, we're not going to incorporate it. We're not going to make it applicable upon the states." Now, here's where the court possibly goes a bit awry. It cites two cases primarily as authority for its decision. One of the cases it cites is the slaughterhouse cases, which makes sense. The slaughterhouse cases happened 5 years after the 14th Amendment and made it, at least in terms of its ruling, clear that the 14th Amendment didn't apply to everyone in the states. But the court also cites Barron v. Baltimore as controlling in this case, which seems exceedingly odd considering the issue in this case, dealing with whether the Bill of Rights is incorporated in the states by the 14th Amendment. Barron v. Baltimore happens 30 years prior to the 14th Amendment actually being a thing. So it's not at all clear why the court in this instance would cite a case that pretty clearly is not applicable to the issues at hand. The court, however, does signal that there may be some fundamental rights that are applicable to the states through the 14th Amendment. But this protection against self-incrimination at this time is not one of them. I don't care about the concurrence right now, but I do care about the dissent. So in dissent in this case is Justice Black. Justice Black is a plain language sort of person. And what I mean by that is, to the extent that if the words in the Constitution say something, it has to be specifically interpreted as it is written. He is the definitive example of a textualist. So in dissent, he argues that not only should we be considering whether these arguments or whether these Bill of Rights should be selectively incorporated to the states or incorporated one at a time, the text of the 14th Amendment makes clear that the Bill of Rights in totality have to be applicable to the states. He said, one, it's textual. Simply reading the 14th Amendment makes it clear that protections that are afforded to individuals from the federal government because of equal protection of the law must be applicable to the states. Furthermore, he looked at the intent of the individuals who drafted the 14th Amendment, and it is very clear that the individuals who drafted the 14th Amendment, who argued the 14th Amendment through Congress, who ratified the 14th Amendment in the states, had it assumed that the Bill of Rights through the 14th Amendment was going to be made applicable on the states. It turns out that Justice Black was persuasive in some part. The idea of total incorporation never takes hold. So despite the fact that he dissents arguing for total incorporation, that view never takes a hold in the U.S. Supreme Court. But the idea of selectively incorporating, or that is saying making applicable in a very specific manner certain parts of the Bill of Rights, does take hold. And really from this time in 1947 onward, we see the court begin to sort of take the Justice Black position and begin incorporating parts of the Constitution very specifically, very deliberately, to be made applicable upon the states. Therefore, in essence, rewriting the idea from the slaughterhouse cases that the Civil War amendments, in particular the 14th Amendment, was not just about African Americans and ex-freed slaves, but was about controlling state governments from being able to infringe upon the rights of its citizenry. Questions? Whoa, okay. How did the slaughterhouse cases affect the selective incorporation? It basically put an end to it. As should be made clear in Adamson, as Justice Black points out in his dissent, the individuals who drafted the 14th Amendment assumed, in fact, it was their intended purpose, that the Bill of Rights was going to be made applicable upon the states through the 14th Amendment. But the Supreme Court shuts that down in the slaughterhouse cases. So the way that it affects selective incorporation is it pretty much shuts the door. So much so that in 1947, when the court revisits this idea, a majority of the court says that no, because of the slaughterhouse cases, because of the precedent there that the 14th Amendment is not applicable in totality to the states, the Bill of Rights cannot be incorporated to be enforced upon the states. And that's why Black's dissent is so important, is because it points out the flaws, the inherent flaw in the decision in the civil rights cases. And so Black sort of pushes the court as an institution to begin considering how the Bill of Rights should be made applicable to the states of the 14th Amendment. Black just argued that it was carte blanche, that, next case you all get, you should sweep in the Bill of Rights in totality as applicable to the states. And the court doesn't take that approach. The court, by its very nature, in fact, courts, by their very nature, are conservative institutions. And I don't mean conservative in the sense of Republican conservatism. I mean conservative in the fact that they don't want to push too far too fast. They might not like the status quo, but they're an institution that isn't hell-bent on rewriting the status quo in one fell swoop. So for them, the idea of incorporating all of the Bill of Rights at one time was just anathema to sort of the Supreme Court's existence. But they do agree, ultimately, after Adamson, agree that incorporation in a piecemeal fashion, slowly, deliberately, over time, is absolutely what was intended by the 14th Amendment. I hope that answers your question. Other questions involving Slaughterhouse and Adamson? Yeah, so the question is, was there any pushback from Congress after the Slaughterhouse cases to see that, because the Supreme Court basically gutted what their intention was? Yeah, but it was isolated. You have to, so this is where taking sort of a historical view is kind of important. In the 1870s, we were in the process of Reconstruction. So we were, the federal government was sort of railroading the South to be in compliance with everything. As we begin to move out of that Reconstruction area, the South was very defensive. And this was one of those areas that they pushed back upon. So many individuals in Congress from the North were reticent about pushing too far in fear of something like secession happening again. And so while you get this very active period of which of the Civil War amendments are a part of, after this era of Reconstruction, of rebuilding the South and incorporating them back into the nation, the South is largely left autonomous. And because of that was because there was strong pushback against the federal government. And also the federal government didn't want to be seen as pushing too far. So while there were pockets of resistance within Congress, Congress did not, for example, lob a salvo across the bow because of what the Supreme Court did in this case. They were looking at the broader political picture of the time and didn't think it was worth the risk to the nation.